A verdict from a Vancouver courtroom just now in a case that shocked a community in Vancouver. Rocky Rambo Wei Nam Kam has been found guilty of first-degree murder. Kam was charged with first-degree murder in the deaths of Diana Ma Jones and Richard Jones, who were found dead in their Vancouver home in September of 2017. Kam had pleaded not guilty, and during the trial, he testified he forced his way into the couple's house, where he said he choked and stabbed Ma Jones and also stabbed her husband and attacked him with a hatchet. He then testified he did not know them and had no reason to attack them, and his lawyers argued Kam believed he was in a video game at the time. The Crown has said the killings took planning and deliberation. For more, I want to bring in CTV News legal analyst Boris Bytensky. Boris, good to have you on the program. The verdict just in, guilty of first-degree murder on 2 counts. This was a very unusual case and an unusual defense. Tell us about that.
That's correct. It was an unusual defense because it was not grounded in mental illness either. So Mr. Kam did not ask the judge, and it was not a jury case, it was a judge-alone case. He did not ask the judge to find him not guilty by reason of mental disorder. He did not rely on mental illness as a defense. He relied on a sort of an offshoot of that type of argument by claiming that he did not have the intention to commit the offense because he had been so engrossed in playing video games that he basically mistook reality for a video game while he was acting. That defense was rejected. And actually, his lawyers did not ask for him to be acquitted. His lawyers asked for him to be found guilty of the offense of manslaughter. And so today's verdict, and it's a lengthy decision that was read out. It just came down minutes ago, so I haven't had a chance to review it. Rejected the defenses and found him guilty of 2 counts of first-degree murder.
As a lawyer, being in a dissociative state is a mental incapacity, but being lulled by a video game, where does that fall? Who would come up with that kind of defense is, I guess, what I'm asking, Boris.
Well, it was rejected because there were significant concerns about Mr. Kam's credibility, and ultimately the Crown said he was just making this up. They said his position wasn't true, regardless of whether it could constitute a defense. They simply said not to believe him, and I would be interested to see what the judge said about those claims. But really, it comes down to a first principles types of argument. If you don't have the intention to commit the crime, then you're not guilty of the crime as charged, or at least you're not guilty of murder. So the defense of diminished capacity or lack of intent sometimes has come up, although not with this specific example of a video game defense that I've heard of before. But the mere fact that you weren't acting intentionally it's a common defense that's raised in our courts, and sometimes quite successfully. This particular case is very unusual for its facts. It's almost like an automatism type claim,
yes,
without an automatism actually being advanced.
Like sleepwalking.
Like sleepwalking, exactly. And I strongly suspect that Mr. Kam's lawyers would have had professional advice from experts. I suspect that they did not get the opinion from medical experts that would support an automatism type defense, or they would have run it. I suspect that they did not get expert opinion to support a mental illness type defense, or they would have run it. So they were kind of limited, I imagine, by the evidence that they were able to put forward in this case, and they proceeded in the way they did.
Boris, appreciate your insight. Got to let you go. Thank you. Boris Bytensky, CTV News legal analyst. Sentencing for Mr. Kam, June 18th. We'll take